And good morning, Your Honor. Attorney Nicole Muller appearing for and with the defendant, Mr. Austin Chronister.
Okay.
Judge, we're in court today for a bail bond hearing. Previously, I had provided notice orally that we would be seeking a modification of the conditions of bond in this case, specifically the no contact order with the individual with initials CSP, and also amending...
With who?
Sorry, initials CSP. If you'd like the full name, I can provide that.
I think we'll need them for the record, right?
Okay, sure. It's Kristen, spelled Christin, Saint Pierre, Pierre. The other condition we are looking for modification on as well today, Judge, is the 24-hour curfew that is currently in place through Justice Point monitoring. We would be asking for modification to a limited curfew. The time that I have proposed is from 9 p.m. to 5 a.m. that Mr. Chronister would have to reside in his residence. That's a brief overview. There was a written submission. I don't know if the court wants me to go into it more at this point, or if you want to first hear from the state. I was not going into further of my argument, Judge, just to get the position of the state, but since the state's now argued, I'd like to make my record prior to a victim being heard.
All right, well, go ahead. It's your motion. Make your record.
Thank you. So first, I just want to say I'm not asking for any conditions relating to the complaining witnesses in this case to be modified. I'm not asking the no contact order with, sorry, Madam Court Reporter. I'm not asking for the no contact order with the complaining witnesses in this case to be modified. So to say that it should be the request should be denied for those individuals, that they're not going to be impacted here. This whole concept of we need to have an absolute 24-hour curfew for those two individuals is absolutely absurd. There's already no contact orders in place with them. There's an injunction in case with one of them. So whether he's at home or not at home, I don't think makes any difference because he's still precluded from being in contact with those two individuals. Also, this, the state, rightfully so, this is what we expect the state to do, saying that these are violent offenses, that he's dangerous against women. Those are the allegations. My client has never been convicted of a criminal offense before. And if we're going to be talking about what the state believes they have, I can tell this court that one of the complaining victims completely perjured herself during the injunction hearing, that the testimony she gave during that time was different than what the state has in discovery. So I don't think it's appropriate to say this is what we have as far as evidence at this point. When we're looking at what
The court could consider the strength of this state's case when considering bail.
Sure.
Okay.
And so right now, all they have are these two women, their statements and statements alone, and that's now been disrupted by the testimony given by one of the complaining witnesses in that injunction hearing, which the state, once I have that transcript, will be getting that. Second, with Kristen St. Pierre, she's here. It's repulsive that the state would try to speak for her. She is an attorney. She knows very well the ramifications of if she allows Mr. Chronister to intimidate her, which there's no evidence that he's done that. She knows that if she got on the stand and said something that's not true, she's risking her livelihood as an attorney. She has absolutely no desire to have a no contact order with Mr. Chronister, and the state's just saying, oh, we don't want her to have one, but that's what the state wants, and there has not been any, where's the evidence that he's intimidated her It doesn't exist, and she's here today if the court needs to hear directly from her. This isn't just, oh, they want to hang out some more. They've been in a relationship for over 10 years, Your Honor. They lived together for over 10 years. It's her home, her livelihood, and she's not a victim. She will
But she
never
may
be a victim.
But she may be a witness in the case, right?
Yes.
Sure, so will hundreds of other people. Does that mean we get a no contact order? Does that mean the state gets a no
Potentially.
contact order?
Potentially.
But even if
And you
she's a
know that.
witness, and I know, Judge, but even if she's a witness, the statute is still to prevent intimidation. And that hasn't been established that he's intimidating Miss St. Pierre. She's an attorney. She can stand her ground. She's a criminal defense attorney. We have some thick skin. And we know that if we got on that stand and said something that's not true, that's going to be very bad for us. But again, there's no evidence that he's intimidated her. So I just don't think it's appropriate to say, oh, because she could potentially be a witness, there has to be a no contact order, because that's not what the statute says. It says to prevent witness intimidation. All in all, too, it's, right now, back to the curfew, I don't see why Mr. Chronister can't try to go to work.
Well, what kind of work does he do besides what's alleged in the criminal complaint?
So his work was with Sotheby's real estate company, but because of him being in custody and now being at home 24/7, he's not able to work. So I just don't think that it's needed to protect the public. I think that a limited curfew is more appropriate. I should note, as I noted in my motion, that 24-hour curfew should be put away for the most serious of cases, and I argued in my motion that this is not that. I recognize that the charges on their own are serious charges, but they're serious charges every day with people who post significant bond that are out without monitoring. He has monitoring. He will be, if he steps anyway, he's already signed all the zones that he can't go. If he's in a 500 radius of somewhere he's not going to be, Justice Point's going to be alerted right away, and then it's likely that law enforcement will be alerted right away. So it really does not, we do not need to have a 24-hour curfew to address the concerns that the state has. I think it's an overreach. And so we would be asking for the court to amend it to a limited, and then also to allow contact with Kristen St. Pierre. And I should note too, Judge, that Kristen St. Pierre has had to uproot everything, find housing. It's been extremely disruptive, and she wants to return home. She has no issues with the defendant. And again, if the court needs to hear from her directly, she is here present. Thank you.
But there's a no contact order, right?
Sure, but she's in the gallery. She's allowed to be there. But currently, there's a no contact order. So they can,
Right.
it's a limited. They can, there's third party allowed for financial reasons because they live together. They've been in a relationship for over a decade. But yeah, right now there's no contact order. She can't have direct contact with Mr. Chronister, but she could still come in and talk to you if need be.
I don't know, state have any questions of her? What?
I mean, potentially, yeah. We also do have JKP who wishes to address the court.
Well, let's take the defense first because they're the one who brought the motion. So if you want to ask her some questions, go ahead.
Thank you. Where do you want her to sit?
She's right here. Right there.
You could just sit right there.
Do you want to just state your name for the record and spell it, please?
Yes, Your Honor. My name is Kristen St. Pierre. First name Christin. Last name is two words. First word Saint, Saint. Second word Pierre, Pierre.
Go ahead, counsel.
Thank you. Ms. St. Pierre, if you could just tell the court how long you've been in a relationship with Mr. Chronister?
Between 10 and 15 years.
And how long have you been residing together?
Since 2015.
Okay, did you request a no contact order in this matter?
I did not.
Do you wish to have contact with Mr. Chronister?
I do.
Do you fear Mr. Chronister?
I do not.
Has he ever tried to intimidate you?
No.
Has he ever tried to threaten you, to persuade you to act in a way you did not want to act?
No.
Are you currently a licensed attorney in the state of Wisconsin?
I am.
Do you understand that if you provided testimony that was not true, that there would be repercussions?
I do.
What repercussions are you aware of? What would happen?
At the very least, I would lose my bar license and my livelihood.
And why would you lose your livelihood?
Because I am a criminal defense attorney predominantly.
And in this matter, do you have any fear that if you were to have contact with Mr. Chronister, that you would be at risk of injury?
I do not.
I have nothing further.
Go ahead, State.
Yes. Did you post the bond for Mr. Chronister at the beginning of this case?
I don't object to relevance. This is not a cross-examination of her. This is, does she want to have contact with Mr. Chronister?
Counsel was representing that she is an ethical
You
attorney.
can
She
ask the
didn't-
question. Go ahead.
Your Honor, prior to any charges being filed, I posted I believe it was $30,000 that was required. I believe it was part of an arrest warrant, but that was before I was aware of what the allegations were.
Did you represent yourself as his attorney viewing him inside of the jail at that time?
Prior to being made aware of what the charges were and being made aware of the conflict, yes, I did.
One moment. Are you aware that SCR rules prohibit a lawyer from providing financial assistance to a client in connection with a pending or contemplated litigation?
Judge, I'm going to object. This is an attempt to,
This is your motion, counsel.
okay, but still, he's not going towards the motion. The motion is for her to have contact with Mr. Chronister. He's using this as a fishing expedition to try to get information about why she did something before there were charges in this case, before she even knew about it. So it's not relevant. This all happened prior to charges being filed against my client. Once charges were filed with my client, she never had anything to do with it. She didn't know what was going on. All she knew was that her partner of 15 years was in custody, and she didn't know why. And no one told her why.
And she can state that on the record. Thank
Okay.
you. Go ahead, counsel.
Your Honor, my apologies if it wasn't clear, but as I previously stated, my apologies, Madam Clerk. Your Honor, as I had previously stated, at the time that I had represented myself as Mr. Chronister's attorney, and at the time that I had posted the cash that was required at the time, there were not charges filed. I did not know what the allegations were, and I was unaware of any kind of conflict of interest. As soon as I became aware of the potential charges, and once the charges were filed, at no time did I represent myself as Mr. Chronister's attorney, and candidly at that time, I am not the one who posted the remaining portion of bail.
Nothing further.
Okay. Thank you.
Thank you, Your Honor. May I step down?
Yes.
Thank you.